Thank you. I'll just click continue. Thanks everyone for joining us. I'm Hannah. I am the former University Drug Policy Chair of SSDP UK, and I'm also doing my PhD with Release at the moment. And I'm not a lawyer or legally trained in any way, so those questions will be directed at Stephen.
Which is an opportunity for me to introduce myself. My name's Stephen Cutter. I'm a solicitor with the charity Release. I am legally qualified and practice as a solicitor. And I work at a charity called Release. So we were founded in 1967, possibly as the world's first charity that deals specifically with drugs. And we also believe that we were the first organisation in the world to offer a free 24-hour drug and legal advice helpline. We have a long, proud history of promoting civil liberties and helping marginalised people gain access to information and support. Predominantly, our advocacy builds on the experiences of our client group and our consultation of people who use drugs. We consider this engagement to be vital because we must always be aware of the danger of designing systems or solutions that we think will work for people, but designing them without actual collaboration. And what's always important is to have a system that will actually solve the problems that people have. We've been providing legal outreach services now since the 1980s, predominantly in drug and alcohol services, but also in services providing support to sex workers and also to those without housing. We have a long history of working in harm reduction, particularly in creating reports that deal with stop and search, decisions on restricting access to pharmaceutical and injectable prescription drugs, considerable work around HIV and legal problems, exclusions from further education due to drug use. And we also run a separate project called Why Stop, which looks to empower young people in their engagement with the police. So over the years, here are some examples of the work that we have done on a policy front. As I was saying, a vital component of our process is the outreach work that we do that then informs the policy work that we look to achieve. Some of our most widely known studies are those on the screen right now. So the numbers in black and white and the colour of injustice, which looked at the racial disparity of treatment of people within the criminal justice system. We've also prepared a report called Taking the Hit with the NUS, of which Hanna was a part, and she'll be able to talk about that more on the future slides. And more recently, we've been looking at how drug markets and drug purchases have adapted to COVID-19. Our policy work regularly features in the national press, and we are an NGO with special consultative status with the United Nations. And our work is often featured in the national press and by the World Health Organization.
And I have to follow that. So SSDP UK is a student-led grassroots network of young people who advocate for better drug policies. We're linked into SSDP Global. So there are local chapters of SSDP around the globe in both universities and community settings. We believe that the war on drugs is failing our society, and we advocate for harm reduction and education to counteract the impact of drug misuse upon our communities. We are inclusive and anti-racist, and we respect the right of individuals to make decisions about their own health and well-being. So that just means we are supportive of people's bodily autonomy, and that includes the choice to use drugs. We do this through our local chapters at universities, and also through our UK network. And we run kind of events and training and get involved in campaigning locally, nationally, and internationally. On my next slide, I have a couple of examples of just a couple of the events we've done, either as local chapters or as SSDP UK in the last year. So these are all kind of virtual events that we've done since the pandemic. So we've got, it kind of ranges from campaigns training to practical harm reduction training. So we had naloxone demos hosted at Leeds, and also then more kind of ethical discussions around drug use and drug policy, including conversations around sustainable development goals and the environment. So the topics we talk about really span kind of everything, and all of our events are decided on and ran by students, although we do invite other people in quite often. So one of the main barriers to changing approaches that we've found in universities looking at university and students' unions drug policy is the concern around legal issues. And quite often this comes from not fully understanding the legal framework that we're operating in. So this session is designed to kind of in detail explain that quite well, hopefully, and also explain what is required of universities and higher ed institutions, and how that can impact on the decisions that you make in relation to adopting a harm reduction approach. We understand that harm reduction is not a kind of fix-all, and it does not make things completely safe, but it does recognise that there are people who will use drugs despite the risk, and we're looking to increase the safety and reduce the risk for these people. Every year we see, awful tragedies coming out of universities, and we know we cannot remove all of the risk, but we're really hoping that we can help you reduce it. So just to kind of talk a little bit around the Taking the Hit report that Stephen mentioned, I won't talk too long on this because I know it's been brought up several times in the other sessions, but just a quick overview. When we did this research, I was a research assistant on it, and we found that 56% of students responding had used drugs recently or previously. 94% of those were using cannabis, and 67% of those were using MDMA. 10% of students also reported that they were using study drugs to enhance their abilities in their kind of academic work. And the majority of students, 86% of students, said that they were using at home, although obviously nighttime economy venues were also included in that. When we were looking at why students are using drugs, 80% of students who use drugs responded that it was recreational, but there was also a number of students, 31%, who said they were using drugs to deal with stress, and 22% who were using drugs to self-medicate. And I think we all know the kind of mental health impacts that university students were facing before the pandemic, and this has only got worse. So it's a really important consideration, and sessions yesterday talked about this in a lot more detail. When we talk to students about how they access advice, 46% said that they would know where to look for advice, so just under half. And of those who knew, 71% said they would talk to their peers as a form of advice, which is why we feel SSDP is really crucial, because we are training and providing advice and information for students who are, even if they're not interested in using drugs themselves, they are likely to have friends and colleagues at university who are, and it just means that a peer-led approach is feasible, and it's what students want. My next slide, very simple question. So is harm reduction needed? Yes. Students will use drugs regardless of disciplinary policies put in place or the legal status, and that's been shown for decades and decades of research, not just our Taking the Hit report. So regardless of your kind of any moral views on drug use, harm reduction is really just the kind of bare minimum you can do to make sure your students are safe and supported whilst they're studying with you. So moving a little bit more towards the discussion we're having today, it's really important that universities and students' unions understand the law that they're operating within. Because when we did the Taking the Hit report, we found that 104 universities included reporting students to the police as a potential outcome of their disciplinary policies. And this is in almost or most cases completely unnecessary. And Stephen will talk more about that shortly. And in the academic year 2016-17, there was 531 disciplinary incidents reported to the police. Now, we didn't gather the data on whether it was 531 individual students, but that's still 531 unnecessary contacts with the police and introductions into the criminal justice system, which could have a huge impact on students' education, their ability to travel, and their future job prospects as well. On top of that, 82 of the universities that we looked at actually included disciplining students for drug-related behaviour that was not a criminal offence. So a large amount of universities are actually going beyond what the legal framework requires of them, and including that in their disciplinary policies, and many student accommodation providers also did the same, which means that students are at risk of not breaking the law, but still being removed from their accommodation, from their homes, and also from their education. We also found that universities were putting mandatory support in place for students as part of their disciplinary policies, which, although may sound like a positive, it's shown in research that quite often if these are mandatory, it's an ineffective approach, and it will actually be detrimental to a student's well-being, as they may not seek support if they need it in the future. And I think on that, it's also just interesting to note that at the moment, there are, UK police forces who are engaging with a harm reduction approach, and they are not mandatory in demanding that individuals who come into contact with them access support. So it seems like quite an overstep to suggest that students should be forced into support, although there are different conversations to be had around fitness to practice policies where there's different requirements.
Thank you, Hannah. So on the legal side of things, I hope there's no disputing now with everything that Hannah said, that there is a need for harm reduction advice and information services. But how does that fit within the legal framework? So the main piece of legislation in this area is the Misuse of Drugs Act 1971. It's a large piece of legislation. It's very technical, and we'll be taking a very broad view of it today. But in effect, what it does is at the back, it has a list of 3 types of drugs, which are Class A, Class B, and Class C. And there'll be a variety of drugs placed on this list on the basis of the harm that they're perceived as posing to people. What the Misuse of Drugs Act then does is it details a range of behaviours that you can or can't do in relation to drugs that are on these lists. So the reason that possession is an offence is because it is an offence to be in possession of a controlled drug, which is a drug that's on these lists, without either an authorisation or a defence to have them. The Misuse of Drugs Act doesn't just cover what could typically be called illicit drugs or sort of criminal drugs. It also covers a variety of drugs that would typically be seen through medical needs, so those available on prescriptions or indeed over the counter with codeine. There's separately a set of regulations that then split all of these drugs into 5 different categories. And this is how you can have access to codeine over the counter in certain strengths and mixed with other drugs. But in other cases, you would need a prescription in order to access it. And then without a prescription, you would be at risk of committing an offence if you were in possession of that. But I just want to make clear, sort of the Misuse of Drugs Act is much larger than just, the typical drugs that we might be talking about, such as cocaine and cannabis. There's a process of consultation in order to have new drugs added to the list, which over the 50 years now of the Misuse of Drugs Act was largely followed. There's been some exceptions. And this gave rise to an issue for the government, whereby they felt that there were new substances coming to market that were being called novel psychoactive substances. And these were coming around very quickly. So there was a situation by which you would have a new chemical compound. It would be banned under the Misuse of Drugs Act, but then a minor change would be made to the chemical compound, and that wouldn't be covered by the Misuse of Drugs Act. Examples of this were mephedrone and then subsequently synthetic cannabinoids as well, which sort of would most typically be maybe associated with spice, but spice was a whole range of different synthetic cannabinoids with minor changes. This led the then Home Secretary Theresa May to introduce the Psychoactive Substances Act 2016, which sort of tried to put an end to the cat and mouse game of drugs legislation by simply outlawing mice. You were left with a situation where psychoactive substances were considered to be any substance which was capable of producing a psychoactive effect in a person who consumed it, and it was also then a substance that wasn't exempted. Examples of exempted substances were those that we would typically see, but which are psychoactive, so alcohol, nicotine, and tobacco, but caffeine, food, and medicinal products. And then a psychoactive effect was seen to be anything that could affect a person's mental functioning or emotional state by stimulating or depressing the central nervous system. There's been limited case law on this since it came into effect, and I would not feel wrong describing it as unsatisfactory. The courts, initially when it was introduced, there was an assurance from both the government and the ACMD that a psychoactive effect needed to be something that was a direct effect on someone's central nervous system. But there have been 2 cases involving nitrous oxide, which have largely done away with that presumption. And now it could be anything that has a direct or indirect effect on someone's emotional state. And that is incredibly broad. And so it's very difficult now to really accurately predict what is and isn't a psychoactive substance. That it's an area that still needs more work on if it's going to remain in place. A major difference with the Psychoactive Substances Act compared to the Misuse of Drugs Act was its intention was largely to disrupt the availability of psychoactive substances rather than criminalise the use of them. So as Hanna said, there is no offence of possession of a psychoactive substance. Any student who is in possession is not doing anything wrong. The aim here was to prevent people coming into possession of it by making criminal offences of supplying people with psychoactive substances or people producing them in the first place. Most of the discussion this afternoon is going to focus on the Misuse of Drugs Act. This is partly because the law is very well established under these offences, but also because most of the offences are mirrored then in the Psychoactive Substances Act. At a university level, we're going to go through the various offences, but the main thing to be concerned about as an institution is the one in bold on the left-hand side regarding the use of drugs on premises. This offence creates a criminal liability for institutions who are permitting or suffering certain activities from happening on site, and possibly the easiest way to understand what those activities are is to first cover the other offences. And again, I just emphasise that, as you can see on the right-hand side with psychoactive substances, unless it's taking place inside a custodial institution, there is no offence of possession of a psychoactive substance in public. And so this would include things like nitrous oxide, which typically comes up more and more often these days. Meanwhile, it does prohibit either the intent to supply these psychoactive substances or the supply or situations where people are producing, importing or exporting them. So possession itself arises when a person is knowingly in possession of a controlled drug without an authorization or a defense. Naturally, this law has been in place for 50 years now, so there's been plenty of time for lawyers to decide what all of these words really mean, and why have one sentence when you can have a paragraph. So possession is considered to be the physical custody or control of a substance. So for example, physical custody would be if you have it in your pocket, whereas the control of a substance could be if you don't have it physically on your person, but have it stored somewhere that you control. And that might be locked in your car, or for example, locked in a safe in someone else's house. In order to be in possession, you must also have knowledge that it's happening. So you need to knowingly be in possession. And this means that you need to know the substance either exists or has existed. So an example in which this can come up sometimes is if you've been out on the weekend and perhaps you had cocaine on you, you haven't finished it, you hide it in the back of your wallet and you mean to take it out and hide it once you get home. However, you forget to do that. And then you're going into another venue, such as the student union, you get searched and the cocaine is found in your wallet. It isn't a defense in that case to say that you didn't know it was there, because the knowledge relates to the earlier occasion when you very much did know it was there. In contrast, if someone hides cocaine, so for example, the same person having been caught once then decides, I don't want to get caught again, so I'm going to hide it in Hanna's rucksack when we're going into the student union, and Hanna doesn't know. So then Hanna gets searched and gets found with the cocaine. In theory, she hasn't committed the offence because she had no idea that it was happening. She's likely to find it difficult to prove that she had no knowledge that I'd hidden the cocaine in there. But in effect, the offence hasn't actually been taking place. And then finally, the requirement of the offence is that a controlled drug is actually involved in here. So if I think I've bought cocaine, but I've actually been given crushed up paracetamol, I've not committed the offence of possession. What I've probably committed is the attempted possession of a controlled drug, which has exactly the same sentencing consequences, but it is different. And it would also be good news for Hanna if that's what I'd then hidden in her bag, because she wouldn't be in possession of a controlled drug at all. The risk this poses to universities is fairly minimal. As I've written, there is no requirement to report suspected cases of student possession to the police. Where this is likely to come up is perhaps if, for example, someone is searched in the course of, well, in the course of daily life, and then a member of staff comes into possession of a controlled drug through having completed that search. Although there's no requirement to report it to the police, the university will need to have policies in place to dispose of the substance safely. And that may be either if you have facilities on site to do that, or it might be through an arrangement with the police to collect them in bulk, perhaps on a regular basis, and then have those disposed of properly. It is a defense to be in possession of a controlled drug if you have possession of it with the intention of giving it to someone authorized to dispose of it at the earliest opportunity. The problem that will often be encountered for people found is that the moment at which they're being stopped and searched, it's usually arguable that there would have been an earlier opportunity to dispose of the substance. However, for members of staff who come into possession of it in the course of a search and then intend to give it to someone authorized to dispose of it, that's a defense that would probably be available to avoid any risk of criminal liability to staff in that situation. There's then possession with intent to supply, and possession is the same as on the previous slide, but here the requirement is that it must be shown there's an intention to give that drug to another person, and supply is considered to be the passing of physical custody or control to another person. So it could be simply me handing or me intending to hand Hannah some of this cocaine, or I've got it hidden in my car and I give Hannah the car keys to my car and then she can access it. Again, it is a defense if a person has no knowledge or reason to suspect that they have a controlled drug. So if I ask Hannah to take a bag filled with powder and I say, oh, can you give this to someone else? It's some painkillers. And she naively believes that painkillers come in a powdered form in a tiny plastic bag, then she doesn't have a reason to know. There's probably some other questions you'd want to ask about her, but she wouldn't know that she has a controlled drug. There is a common misconception that people believe that if they're found with drugs and then they say, it's not mine, I'm holding it for a friend, that this is a get out for possession. And it's not, it is in fact an admission that you intend to supply it to somebody else. It's incorrect that it makes the problem less serious. It actually makes it much more serious because it's an admission that you intend to supply a drug. So certainly if people say that, I would encourage an investigation as to whether that's because they're operating under the misapprehension it's going to make things better, or if it's true. Likewise, I would also encourage you to not ask every time you search someone, be like, oh, were you just holding it for a friend? Because that wouldn't be a problem. And then inevitably they say, oh yeah, no, that's what I'm doing. And then things get much worse for them. As with possession, there is no requirement to report suspected cases of possession with intent to supply to the police, though again, it may be helpful to have a relationship with them to arrange for the disposal of these drugs. There's then the Misuse of Drugs Act then further creates an offence of supplying drugs, and this covers both offers to supply and actual supplies of controlled drugs. Separately, it also creates offences for those involved or concerned in the supply of a controlled drug, so conspiracy cases, and also what's termed aggravated supply, which is probably less likely to arise in an institution such as a university, because that will often involve using minors as couriers, or if it takes place in schools, but not universities. So supply happens when someone actually supplies a drug to another or is offering to do this. And the offence at law is committed on regardless of whether this is a giant commercial supply situation. So I've just imported a bunch from another country and I intend to sell it on at bulk in kilos, or whether I'm passing on a small amount to a friend in a social situation. It is also met arguably when two people are sharing a joint between them and one person passes the joint to the other. At law, that would be considered to be a supply. However, it is recognised that that is largely a disproportionate way of dealing with an offence such as that. And guidance from the Crown Prosecution Service includes information there, such as maybe treating those cases as joint possession, where two people are seen to be in equal possession of the substance, rather than one person has the substance and is intending to give it to another person. Supply does pose a risk to universities, not because the supply itself is something that needs to be reported to the police, but it can arise under your obligations under Section 8, which we'll cover in a few slides' time. It is also an offence to either cultivate cannabis or produce controlled drugs and psychoactive substances. Students and anyone are allowed to legally possess cannabis seeds, but anything that you do that is seen to germinate them or cultivate them is an offence. So this can be the planting of seeds, watering of them, feeding of them, really any action that takes them from a dry seed into something that's going to develop into a plant. Production is then sort of seen as the next stage in that process. So that could be once the plant has fully grown and then stripping away the buds away from the plant itself. I suppose it's feasible that this is going to arise in some occasions, but I mean, it seems unlikely that many people are using their student accommodation to cultivate cannabis, though perhaps that's misguided on my part. There's a separate offence of production, which is, I don't want to get distracted by this because it's a very complicated offence, and we probably don't have time to get down into the details of it. It probably goes beyond what will often be seen in a student context. So it could be bulking out drugs with adulterants in order to make them go further for commercial sale. And then there's also a separate offence of producing what's called a preparation, which is seen as putting a drug into a form suitable for consumption. There is some, I suppose, debate ongoing about whether this includes baking cannabis into a cake or rolling cannabis into a joint, and whether that's producing a preparation. I don't believe that it does, though the words could be construed that way. And I think there's 50 years worth of cases now under the Misuse of Drugs Act that show that that's not how it's being interpreted. There is a risk to universities, as these are again Section 8 offences that you need to prevent from happening if they come to your attention, but there is no overriding obligation to report either cultivation or production to the police. Importation, exportation, again, this seems unlikely to probably be a major issue within university settings, but it's certainly an offence under the Misuse of Drugs Act. The range of licenses that you need from the Home Office in order to lawfully import or export licenses are complicated. On the Home Office website, you can see a list of over 500 of the most commonly encountered drugs that they have at the border, and they'll tell you what schedule they're in and also what licenses are required. I would, I suppose, emphasize here that both the Postal Service and a range of couriers have drug checking services within their headquarters, so as post and mail goes through them. And so if you're suspecting that a package that has arrived at your institution contains drugs, I suppose I don't know what the basis for that belief would be if it's already made its way through the whole postal system. Certainly, if there's an intention to check students' post through anyway to see whether they are perhaps importing drugs from another country, I would strongly advise considering getting separate legal advice on the legality of interfering with students' private correspondence. This brings us through to the Section 8 offences, which are the bulk of where the risk arises for a university. So under Section 8, there's a criminal liability for occupiers and others involved in the management of premises. But the offence only arises if you allow or don't attempt to stop certain activities from taking place. And it's largely made up of 4 elements. So in order for the offence to take place, you need to either be an occupier or concerned in the management of a premises. You need to permit or suffer it happening. The thing that you're permitting or suffering needs to be one of 4 specified activities, and then it actually needs to be happening in your premises. So if it's happening somewhere else, it's not covered by Section 8. This does pose a risk. This does give rise to criminal liability to institutions, and not just institutions, but anyone who is concerned in the management of premises. But there is no overriding requirement to report any of this behaviour to the police. What you will need are processes in place that can show, in the event that the police were to become interested, that show that you have processes in place that show that you don't permit or suffer these things happening. So, did I miss a slide? No. So, firstly, the requirement is whether or not you're an occupier or concerned in the management I'm not aware of any cases that deal specifically with student accommodation, but Section 8 has certainly been used against the owners and managers of nightclubs and other licensed venues. It's been used against the managers of hostels and day centres for people without homes. And I think on the basis of who it has been used against, it would be completely reasonable to believe that it could be used in a student context. The test, in effect, if you're ever wondering whether it might apply to something that you're worried you might be concerned in the management of, is do you or people acting on your behalf have sufficient power to exclude people from it? So certainly in student accommodation, you probably do because you have licensing agreements with all of the students. In any sort of licensed premises, such as student unions or bars, you probably have the power to remove people if they're acting in an antisocial way. And so again, you would probably have the sufficient power to exclude people if you needed to. The next issue is whether you're doing what's called permitting or suffering the activity. So in order to, firstly, is whether you actually have any knowledge that these behaviors are taking place. And if you're not, if you don't actively know that it's taking place, are there reasonable grounds to suspect that it is? So permitting would be done with sort of active knowledge and with permission. I would presume that no student accommodation agreements are allowing any of the activities that are prohibited. I would suspect that all of them actively say you cannot smoke in your room, you cannot use or supply drugs from your student accommodation. So there'd certainly be no question in these cases about you permitting the activities taking place. An issue then is whether you might be seen to have suffered them. And this is the phrase often used is whether or not you're turning a blind eye to reports of it happening, or if you discover it happening, whether or not you're failing to take any action. And we'll deal with that with some examples on the next slide. And then premises largely covers over with this issue of whether you're concerned in the management. So where does it actually apply to? I think it would certainly encompass the majority of properties that you would anticipate a university to have. So certainly classrooms, any playing fields that are accessible only by students, student halls of residence. If you have sort of a gym, certainly a gym that's sort of done through a swipe card, it could cover any range of places. So the question is then are the behaviours that are taking place one of those which are prohibited under the Act? And that was a few slides ago now. So as a reminder, it's producing or attempting to produce controlled drugs, supplying or attempting to supply controlled drugs, the preparation or smoking of opium, which these days is unlikely, but it's one of the behaviours. And then finally, the smoking of cannabis, which is probably the one that is most likely to come up based on the information we have from taking the hit that 94% of students who use drugs are smoking cannabis. Places where this has happened before have included homeless day centres. And this is around whether or not they were seen to be permitting or suffering it. So the day centre in question had processes that said if drug dealing was taking place, that these people should be banned and not allowed to return. There were continuing reports that drug dealing was taking place on their premises, and the police ran an undercover operation that showed that this was regularly taking place. They had policies which again called for the temporary or permanent ban of people, but the police were finding that these simply weren't enforced. So if someone was caught dealing drugs whilst on the site, they might be told that they couldn't come back, but then if they did come back, the ban wasn't actually enforced. And this amounted in the prosecution to saying that they were effectively suffering it happening. They didn't have any policies in place that actively deterred the behaviours that they were supposed to prevent happening. This gave rise to the criminal liability then under Section 8. I want to sort of emphasise that it's not a case that you're criminally liable just because these things happen. So if someone is found smoking cannabis or supplying drugs from student accommodation, that doesn't give rise to the criminal liability. The issue is whether or not you're allowing them to do it or then not taking active steps to discourage it from happening again. I don't necessarily believe that an immediate reaction needs to encompass sort of completely insulating yourself from any liability by taking a zero tolerance approach. It might be that you can take other approaches, that some of which you'll already have in your policies and procedures. So for example, under the Health Act, you already have requirements to not allow the smoking of tobacco or cigarettes or other substances in your halls of residence. And that process that you have there of warnings may be perfectly sufficient to deal with anyone found smoking cannabis in their rooms, where it sort of begins with a warning of some description and then perhaps escalates further along the line if there are further infractions. Other of the behaviours may require brand new processes that you don't currently have. But certainly it's not a requirement to take a zero tolerance approach. You just need to be able to show that you have a process that does deter this from happening again. And then if it does happen again, what you do to make sure that that deterrence is actually a valuable disincentive. I just want to talk briefly about the impact of criminalisation and taking perhaps a zero tolerance approach. There are behaviours involving drugs and the misuse of drugs that will bring you within the ambit of the criminal law. And this is understandably of concern to anyone considering taking a harm reduction approach. What I hope is at least clear is that the behaviours that can bring you within the criminal law are pretty limited to specific behaviours. And there's no obligation to report many of these to the police in the first instance, though a good relationship with the police is perhaps helpful at then dealing with some of the ramifications of having a harm reduction policy, which is that you may in turn end up in possession of a huge amount of drugs that you're now confiscating from students. What you do need to do is make sure that you have records that demonstrate that you're not permitting or suffering things from happening. And I believe that there's substantial flexibility within the criminal law to cover probably the vast majority of situations that are most likely to come up. I think if you wish to approach this as having sort of a drug-free student population, that there are two options available, which is banning drugs, or alternatively, you could ban students. And historically, the ban on drugs has not been particularly effective at having a drug-free student population. The danger with criminalising people is that the involvement with the criminal justice system is one of the severest harms available through involvement with drugs. If someone's involved with or found with cannabis for the first time, then they may receive what's called a cannabis warning or some other out-of-court disposal. But thereafter, there's a genuine risk that they're going to receive a criminal record. And certainly if it's anything other than cannabis or cat, there's a very serious risk that they'll move straight on to some form of prosecution. This will then have severe consequences for their employment. It will need to be disclosed on a DBS check for a number of years. It can also have an impact on their ability to travel and take advantage of visa waiver programs in the future, and maybe a breach of, certainly with international students, of their own agreements in studying in the country in the first place. I think there's a very real risk that criminalisation poses to people, and there's a need to ask questions about, if the law doesn't require you to introduce people to the criminal justice system, why would you start there? I don't think that the majority of drug use is either problematic or self-medication. What we've seen from the statistics is that 90% of people are using recreationally, and the vast majority of these people will not go on to develop substance use disorders or any problems with drugs. I think it's understandable to look at it through a lens of self-medication and health impacts, but I think it's also important to recognise, I think Laura mentioned this on her talk on Monday, which is that there's an awful lot of people doing this because they find it pleasurable. And I think it's important to recognise that that's one of the reasons this is happening. I think if you're having discretionary policies, so if you are going to introduce harm reduction policies, then to monitor how those policies are actually being implemented. Certainly in the studies we've done looking at racial disparities in the treatment of people and the criminal law around drugs, is that there's a huge disproportionate impact on non-white people in the use of these out-of-court disposals and the then subsequent prosecutions. I think it would be very important to monitor how any discretionary policies perhaps continue to disadvantage people from minority backgrounds if those are being implemented but not properly monitored. I think that's me done. Sorry, I've spoken for ages, Hannah.
All right. Thank you so much, Stephen. Honestly, even though I've read this presentation like hundreds of times, it's still fascinating. So I'm just going to talk a little bit about what is actually possible within the law then. Hopefully you now feel like you have a good understanding of the legal framework we're working in. So I think first and foremost, the easiest thing to do is to move away from having a zero tolerance policy and punitive approaches to disciplining your students. I say this as a student who hasn't worked in a students' union for a while. So I know that you can't just wake up tomorrow and have that done. I know there is, you know, a lot of bureaucracy to deal with, but there is no requirement to have a zero tolerance approach, as Stephen just said. And this could be one of the kind of most positive things you could do for your students in terms of not disciplining them, not reporting them to the police, but also to encourage students who need support to actually feel like they're able to approach you and talk to you. So you can absolutely start to move away from a zero tolerance policy today if you choose to. And that's completely acceptable within the legal framework that we exist within. So the second thing is to provide information, advice, and support for your students who use drugs. And it's really important. We at SSDP have lots and lots of resources that we've pulled together, but it's really important that you're looking at this, as Stephen said, acknowledging that a lot of people who use drugs are doing it recreationally, they're doing it for pleasure. So making sure that that is embedded in the information, advice, and support you're giving is crucial. If you're sharing advice and resources that act as though every single one of your students who uses drugs is using it problematically or dependently, it will only kind of shut those students out of that support. But yeah, providing that advice is, again, a bit like completely okay within the legal framework. You can provide harm reduction resources. One way to mitigate some of the other worries around this, so if you're looking at reputational risk specifically, one good way to do this is to share resources from other expert organizations rather than creating that information yourself. And we at SSDP and Release can probably signpost you to lots of places that provide amazing advice already. The next thing is providing drug testing kits. I'm sure everyone heard Guy speak on Monday talking about drug checking and their work with the Loop. So when we're talking about drug testing kits, we're talking about single-use kits in most cases that would be given or sold to students for them to use within their own homes to test the drugs that they purchase. I'm going to talk a little bit more about this on the next couple of slides, but so we're talking about individual kits that students would take home, as opposed to suggesting you attempt to get a drug checking facility on your campus, as that would take a very long time, and the Home Office licenses that are required for that are intense. However, we are creating a drug testing toolkit at the moment, and we do hold the idea of having formal drug checking sites as kind of the gold standard and the goal as to what we would love to see, but we kind of are aware that it's impractical at the moment. The fourth thing on this list is just amnesty bins. One of the things that we've talked about a lot with students' unions who are looking at providing drug testing kits has been a conversation around what should students do if they use a testing kit and the result is concerning to them and they no longer wish to take the drugs. And some institutions have amnesty bins without testing kits, but we feel that if you're providing the two together, it's a good harm reduction approach. It encourages students to not take something if it's not safe, and it gives them a really safe and legal way to dispose of them. There are issues around amnesty bins, as Stephen said, in terms of collecting the controlled substances that would be within them. So you would have to have conversations with your local police forces about what exactly that would entail, because you would be technically holding that on your own premises, but it's a safe way to do it. And police are quite often quite supportive of this as a method. Yeah, so just one final thing that's not mentioned on here, which I will talk about a little bit more as well before we end, but is just to make sure that everything that you're doing is future-proofed. I know that when I was a sabbatical officer, it was tough because I knew I was leaving in a year or two. So making sure that all initiatives you're doing are kind of involving a university-wide approach, getting staff from all kind of areas of the university in, to make sure that everyone's on the same page, and also to make sure that it's long-lasting. and isn't reliant on individual students to kind of carry the weight and bear the burden of doing this work. So one of the kind of biggest questions we get is, does harm reduction condone drug use? And I think it's a fair question, especially if you're new to this area of work. I think the answer, as it is quite clearly on the presentation, is no. Harm reduction has a really long history, and it is so much more than these quite small conversations we're having about university campuses. You know, harm reduction is embedded in treatment services across the country in the form of needle exchanges, in the form of providing opioid substitution therapy. Yeah, it's a lot of a bigger thing than just this specific thing. So the focus of harm reduction is really to meet people where they're at, as I think we said at the beginning, and just focuses on making people safer. And as I mentioned before, you know, police are, in some areas of the country, they are adopting a harm reduction approach themselves, and organisations like the Loop receive support from police in the form of letters of comfort and agreements to not police those specific festival sites where they're testing. So harm reduction is much more than just what we're doing on universities, and it involves everyone, including the police. So yeah, we're not condoning drug use. And I think personally, in my experiences when working with universities, this has very often been framed as a legal question and a legal concern. But when we've had kind of wider conversations about this and we've dug in a little bit more, it's very much come across as actually it's a moral issue. It's a question that stems from a moral basis. And I think on my next slide, I just highlight this a little bit more. Just with a few definitions of the word condone, I think it's really important to remember that although the legal framework is an important aspect to understand, you are also battling against, you know, moral viewpoints that stem from a lifetime of seeing people who use drugs being stigmatized, and also so many issues and worries around reputational risk. So understanding the legal framework will not alone make this work easy.
Definitely, Hannah. And I think one of the things we were talking about before was that when it comes to condoning drug use, there's a genuine issue, I think, of having a balanced debate or discussion about this. I think the anti-drug position is so firmly established as sort of requiring abstinence and prohibition that anything other than abstinence and prohibition is very much seen as being, or taking a pro-drugs approach to anything. And I think that's seductive in its simplicity, but it isn't accurate at all. I think, as you've said on the slide here, is that, you know, condoning something isn't the same as encouraging it or endorsing it. And I don't think harm reduction does condone or endorse student drug use, but what it does do is recognise a practical reality, which is that students are taking drugs, and that as people who interact with students, your choices are then pretty limited to pretending that isn't true and continuing with a zero tolerance policy that says that abstinence is the only option, or looking at it and considering what interactions can you have that reduce the risk of harm to people who will be doing this anyway.
Yeah, absolutely. So moving back just to drug testing kits, this is probably the area that we at SSDP get the most questions about. Over the last kind of academic year since September, I think we probably get a couple of requests a week to have meetings and discuss the kind of practical elements of how to provide drug testing kits on your university campuses. And we are not, you know, we are not legal experts on this. We are a group of students. So we're creating our drug testing toolkit to hopefully answer all of these questions and more. And we're working with Release and other organizations to do that. But these are the kind of comments that we get the most. So the first two relate to kind of people who aren't students being on campus and specifically being attracted there by providing drug testing kits. So obviously it depends on how you have set up your kind of drug testing kit providing model. It depends whether you're selling them or giving them away for free, and who is kind of funding that. So there are obviously concerns about testing kits being picked up by non-students if you are funding them and providing them for free. But we feel it's quite an easy obstacle to get around just by having students agree to kind of flash their student card to show that they are a university student here. They're supposed to be on your campus. But we do hesitate when it comes to discussions about kind of further documenting who those students are. So we wouldn't recommend that you take their kind of personal details off their card, but that should hopefully be enough to provide you the kind of comfort that they are going to your students. And more specifically, there's a real worry about people who are selling drugs being attracted onto your university campus. And I think this concern has kind of risen in the last couple of years. There was a few news stories, I think, in 2019 about this. But I think it's not an unsurmountable obstacle. But also there is a consideration to be made of the fact that some of your students may be selling drugs for whatever financial reasons. But there's no way for you to know that just from kind of having that small interaction with them. And if you're saying, students need to flash their student card and will only be allowing like 1 or 2 kits at a time, you're unlikely to attract people that you don't want onto your campus. But also I think quite often when we're in closed sessions talking about this, I think at least most of us in SSDP are quite of the mindset that if drug dealers decided to use testing kits, at least the supply is getting safer. And it's a positive, although obviously we're not the ones funding these kits. The kind of final concern is around what if someone does use a testing kit and still has a negative reaction to their drugs. And I completely understand the concern with this, but harm reduction approaches, and especially testing kits, at no point should you ever be telling students you are making their drug use safe. This work is to make drug use safer, but it does not reduce or remove all of the risks. So it's important that this is clearly kind of labelled and signposted, and this would be a responsibility that the manufacturer would also have. So there would be labelling on these testing kits and the kind of related information that they provide, that would also be included there. But it would also be on you to just make sure that you're saying using a testing kit does not make your drug use safe. And it's really unlikely that you would be liable in any way if that were to happen. But also, there's so many different interacting factors to an individual having a negative reaction to their drugs. Yeah. Stephen, did you want to add anything on that?
I think you covered most of it. And I think this particular question is part of an ongoing piece of work. And so I suppose my conclusions aren't firm on this yet. But I agree that there would be certainly an initial situation whereby if the test was faulty, then, whether or not that's actually the institution's responsibility, or whether those questions are then better directed at the manufacturer if someone does have a negative reaction. I think there are also questions to be dealt with then around, is it actually because of the test that any of this happened, or would the person have most likely taken the drugs in any event, and then how that fits in with the model. But I think I would agree that so long as the information and advice that you're providing to people is sensible and is sort of couched in terms that, the safest thing to do would be to throw this away and not use it. But other than that, here are things that you can do that minimize the risk that it poses to you. Then I think that's completely sensible. Certainly on our website, we've got information about a huge number of drugs, how they're taken, and the things that you can do to make them safer. On our website, we don't consider that gives us a risk of liability for the advice on there, but that's because our advice is checked and we know it to be accurate. I think it's just making sure that you're talking sensibly about things rather than giving guarantees that are perhaps beyond your capability to do. Does that make sense?
Stephen and Hannah, we've got a couple of questions in the chat in the Q&A box. I just wanted to draw your attention to them just before the end. Stephen, I know that you can't see it. Would it be helpful if I read 1 or 2 of the questions out, and then we'll see how many we can get through? Is that okay?
Yeah, we've just got Hannah, I think, has one more slide, and then.
Okay, sorry, I didn't realise there was another slide. Sorry, I thought that was the end. Sorry, carry on.
This might actually, I haven't checked the Q&A, but hopefully it might answer a couple of questions. But this is just a really quick slide just to say that the kind of most important things we see as part of this work is building a network that is wider than just your university. And Ali Goldin spoke really well about this on Monday, talking about the kind of Bristol approach, taking a citywide approach. And we would really recommend that you get your local councillors, your local police, your local drug and alcohol services involved, because they can also provide you a lot of advice, and your police can support you in any of the legal concerns you have. And also just make sure student voice is at the centre of all of this, and we can do that and help you do that via SSDP if you want to chat to us about setting up a chapter. The end.
Questions?
Sorry, I realise we've actually talked for almost an hour. I can't believe that.
I think if I stop
the sharing, don't feel bad.
Everything. Great.
Can you see the Q&A box?
I can, yeah. So it's just under open. So we have one here, which is, can you expand on how universities can demonstrate that they have processes in place that they aren't permitting or suffering behaviours? I mean, I suppose a starting point for some of them would be, for example, that in the licensing agreements for student accommodation, that it's clear that there's no question that you're permitting it, because it's clear in any written agreements that students are signing as part of their accommodation agreement that they won't be carrying out these activities. And then I suppose what you then have is presumably at many institutions a disciplinary process that sort of talks about, oh, if X happens, then you fall into this particular process. And then what you need is to demonstrate that those processes have a deterrent factor. So whether or not it's, for example, some form of warning on a first occasion, and then perhaps either a further warning or a notice that further action is going to follow. And then a progression along perhaps a path of increasing severity. I wouldn't want to be too prescriptive, I suppose, about what I think that looks like. But I think so long as you have processes in place that demonstrate we don't consider this to be acceptable, and here's what we'll do if we find it happening, then so long as you're following the process that you have on paper, and that process has a deterrent factor, I think you can achieve that for paper evidence in order to show you're not permitting and suffering, if that makes sense. Is that okay?
Yeah, and I think, you know, these policies, it doesn't just have to be drawn into your kind of rental agreements and the more formal agreements, but it can just be under your kind of substance misuse or drug and alcohol policy. It can just be popped up on your website to make sure students are aware of it. And you can also make them aware during their freshers periods and throughout their time at university of this. So we've got a question from Ada saying, if it's possible, is it possible that university security could handle certain drug-related offences, and what mechanisms would need to be in place to implement this practice as standard? I'm going to jump in first and just say, we have seen some really awful treatment of students by university security recently. And I think that in terms of giving this power and responsibility to them, yes, they can definitely be involved in the process, but I think I would really like to see quite intense training around this if that were the case and that was what you were, you know, opting to do at your university. And I think there needs to be an understanding of the kind of racial disparities in terms of policing these drug laws and how they were actually originally written and designed. But security, obviously, as a part of the university campus, do play a part in this, but I would hesitate to make them the kind of main, I don't know what the word is, the kind of main person related to this. But also, I think this is a common question in drug policy, is whether it should be dealt with by criminal justice or by health. So the same argument can kind of be said with security versus like your support services dealing with this in universities.
Yeah, and I suppose from the legal perspective on handling certain drug-related offences is that invariably, I suppose, if you're taking perhaps some of the approaches that we've talked about today, where you're not contacting the police, but perhaps you find a student who has possession of drugs and you now have the drugs, that member of staff is now in legal terms, they are now in possession of a controlled drug. If your policy requires them to give it to someone else, they are in possession with the intent to supply it to someone else, and they will eventually supply it to someone else. So what you'll need will be mechanisms and policies that ensure that, firstly, the staff who come into contact with these substances are protected from committing criminal offences themselves. So one of the defences is you have possession of it in order to dispose of it or give it to someone authorised to get rid of it, which includes the police. And that's where then, I suppose, some form of working relationship with the local police is needed, so that the staff who then are taking this harm reduction approach are then able to relieve themselves of the substances that they now have in their possession that would ultimately amount to a criminal offence. So I think that's what you would probably need to have that in practice.
Ada, does that answer your question? Well, if you post in the chat if you want us to expand, but I'll move on to the third question. So we've got a question from Chris, which says, as a bar manager, if we go down a harm reduction approach and give them a talk, warnings, try and support them and so on, but they disregard either any help we offer and just keep bringing drugs to the premises, then surely taking it further is correct. I wonder if some people will play the system, as it were. I understand the implications of ruining someone's career. Sorry, I've just taken my glasses off. And so on for experimenting and getting caught once. So I am in favour of harm reduction, but I'm also worried that we will seem as a joke and students will talk and say this, say that, you'll be fine. And that dealers and spikers will use this and ruin it for people that need the help. Does that make sense? I'm gonna just jump in and say drink spiking is a very different issue to an individual choosing to consume drugs. And I don't think we're in any way, I think that conversation is quite separate to this. I understand why they would kind of come up in tangent, but things like drink spiking should not be included in your harm reduction approaches or policies. That should be a separate policy looking at that. I think it's a very different legal framework as well, which I do not know the ins and outs of. But I would say that if that's an issue you're having, speak to your local police and get more advice on how to handle that.
Yeah, I think just on a follow-up here as well, Chris, is I suppose this is the importance then of having a process in place that actually acts as a disincentive. So to use maybe as a bar manager then, or the bar manager in a student union, then it might be that something that you can do to show that you're not suffering this activity taking place is that, you know, on that occasion, they are told to leave and that they can't come back, and that there's some form of temporary ban that is actually then properly imposed. If it were to happen, because I think that immediately shows that you haven't discovered this activity and are now suffering it happening by doing nothing. What you could then do in the future is whether you need to explore longer term bans if it does happen again. I think in the context of student unions, there's a really interesting discussion to be had then around whether exclusion should be sort of total, so you can't come in at any point during a 24-hour period, or if students can then still engage with it for the purpose of some sort of societies and other functions, so that their educational involvement in a wider sense isn't impacted. But, you know, if someone is repeatedly putting you at risk of criminal sanctions, then I think there is a need for you to have these processes in place to protect yourselves from them. I suppose my underlying point is that in order to protect yourself from these criminal liabilities, is you don't need to start at removing someone on a permanent basis and calling the police. I think there's more nuance to it, but certainly if it's repeatedly happening, then you do have obligations under Section 8 to try and prevent that from continuing to happen.
Yeah, I would just want to apologise to Chris as well if it felt like I was struggling to read his question. It's not because of how it was written, it's literally I just took my glasses off. But yeah, I think everything Stephen's just said is right. And I think as well, looking to speak to other people in your kind of local area who are in the same role as you. So you probably have a nighttime economy kind of committee or meeting in your council. I would say speak to them and see how they're dealing with it. And if it's, you know, if you're having the same issues, look at if you can kind of come up with a more community-based response that is wider than just your one club. So that way you're not being seen as acting differently to anywhere locally, if that's assuming they're willing to take a harm reduction approach to an extent as well. Hopefully that answers that. And I think we've got one more question just come through in the chat box. Oh, in the Q&A. It's in there. Where's it gone? Sorry, my screen is jumping around. Ada was also wondering whether the university should clearly explain in their policy how each class or quantity is dealt with to ensure that the way each case is dealt with is consistent. Stephen, I don't know what you think about this.
I think it's an option, definitely. I think there's maybe no should or shouldn't that you could answer conclusively on that, because I suppose if you have something that's completely firm, then it's very difficult then to have situations where you say, well, actually, this is exceptional and it doesn't actually fit within what we have. But certainly, I mean, the law doesn't prevent you from doing it in much the same way that the law doesn't prevent you from having a zero tolerance policy, and it also doesn't prevent you from doing some of these sort of more harm reduction focused routes. I think it's more about making sure that you can demonstrate what you're doing and how your processes are actually being followed. What you need is an actual policy that is actually used, rather than something that exists on paper only and is then subsequently not enforced or not followed in the future.
I think with this one, it does add a level of complexity for universities that might not be necessary, because although at the moment the kind of class system and stuff is set, there is the ability for changes to be made to this, and it isn't unheard of that happening. So I would say that with university policies that tend to be put in place for a couple of years and reviewed kind of infrequently, there is again a worry that you might end up having an approach that's actually quite different to what the Misuse of Drugs Act classes could be, for instance, if in the hope that they eventually change. But I just think it may add a level of admin responsibility that potentially would get forgotten about.
Amazing. I think we've reached the end of the questions. Thank you both so much. I let that carry on for an extra 10 minutes. I hope that was okay, just because it was such helpful. It was so helpful to get your feedback on those questions. But thank you both so much for joining us. That was absolutely amazing, and I'm sure will be a really useful resource for all of the attendees and for people that couldn't make it today. So thank you so much for joining us.
Thanks for having us.
Yeah.
Amazing. So we've got a short break now, and then at 2:30 we'll be joined by Public Health England and Rachel from UE, Rachel Colley from UE, who are going to be talking us through the Drink Rethink programme, which is all about which is a student alcohol intervention. And I don't want to spoil it by telling you too much. So join us at 2:30 to hear more. Thanks, everyone.
Thank you. Take care, everyone.